Hello dear students, welcome back to Abhiram IAS Academy. In this video, we are going to analyze APPSC Group 1 previous year questions that was given by the APPSC in Polity section. So in this video, we are going to discuss in a detailed way the Polity questions, how the APPSC has set up its questions to complicate the Polity section. Let's get into this. So this is 2024 screening test, which is 2023 notification. The APPSC PYQ analysis, polity. We will be discussing previous year questions, techniques, traps and elimination techniques that was there. So the first question is, which is 31st question, component B, office of the whip. Which of the following statement or statements are valid regarding the office of the whip? The question here is about the whip. So what is whip? The office of the whip is mentioned in the Constitution of India. The Constitution of India. It operates primarily through parliamentary convention and party practice. That means parliamentary convention and party practice. The office of the whip mentioned nowhere in the Constitution of India. Nowhere. So that is the first thing we have to understand. What is the first statement? Although not mentioned in the Constitution of India, okay, this is right. It was not mentioned in the Constitution of India. So what next? The office of whip has, however, been incorporated in the rules of the House by the leaders and chief whips of recognized parties and grounds in Parliament Facilities Act 1998. The first half of the question is true. The first half of the question is true. But when we are coming to the second half of the question is little bit ambiguous and doubtful. So keep it on hold. The second statement here is the role of the chief whip of the government party in the Lok Sabha is served by the Minister of State. Yes, the second statement, let's get into second statement here. The role of the chief whip of the government party in the Lok Sabha is served by the Minister of State for Parliamentary Affairs. So again, here one factual check we have to make: Minister of State for Parliamentary Affairs, which is doubtful. Is it really Minister of State for Parliamentary Affairs? We have to keep it on hold. Next, all political parties, one extreme here, which is qualified trap. All political parties, whether ruling or opposition, will have their own whips in the government. Yes, it's absolutely true. All political parties, whether it is ruling party or opposition party, the leader of that particular party will appoint one person, one senior most member from that political party will be appointed as a whip, which is a convention, which is not any governed by any statutory law or any constitutional practice, but which is party convention or political practice that is generally generally prevailing. So all political parties, whether ruling or opposition parties, will have their own whips in the government. It's absolutely true. So 3 must be in the answer. So we can eliminate first option, fourth option, and now the debate is there between 2 and 3. So so only 3 should be correct or 2 and 3. So without reading 4, we can eliminate this fourth option also. So what is here? Now only 2 and 3 or only 3? What is 2 and 3 here? What is 2? The role of chief whip of the government party in the Lok Sabha is served by the Minister of State. It's true. It's wrong. The answer here is the Minister of Parliamentary Affairs. So this is the ministry. Here, the wrong ministry was mentioned here. So it's a trap. So it's a deliberate trap. So the answer here is only 3. This is the answer. So let's analyze it now. As we discussed here, the first statement is incorrect because it is only partially correct. The only first part of the question is correct. And the second, designation trap, which is we have to keep it in mind, designation trap, where the Minister of Parliamentary Affairs was given as Minister of State for Parliamentary Affairs. There is a difference between Minister of Parliamentary Affairs and Minister of State for Parliamentary Affairs. Third one, the anchor statement, which is correct. All political parties will appoint their own whips in the parliament. True. What? Incorrect. Fourth one, absolute qualifier trap. The words not responsible only creates an over absolute statement about accountability. So finally, we arrived at one answer, which is third statement only correct. So only 3 is the right answer here. So that we have to keep in mind what traps that APPSC is trying to keep to make sure you select the wrong one. So please be aware of this. Next, the second question. The second question is given on public versus private bill. So generally we have to have a good understanding on what is public bill, what is public bill versus what is private bill. So what is public bill and what is private bill? Generally, public bill is introduced by minister. The private bill will be introduced by not a minister, but an MP. An MP can be ruling party, an MP can be opposition party. So any person who is not a minister, who is not a part of council of ministers or a cabinet, will be a private member. So any MP, whether he is from ruling party or an opposition party, if that particular MP introduces a bill, proposes a certain bill in the parliament, then it will be called as private bill. Okay, that is the first difference. And the second difference here is if a government bill has to be introduced in the parliament, must be informed, like must be given notice, generally 7 days before. But when it is coming to private member bill, 1 month prior should be informed to the Speaker of Lok Sabha. So that are the small differences are there. Now let's get into the question here. So what is question here? In the context of distinctions. So as we discussed before, differences between the public bill and the private bill. So in the context of distinctions existing between a public bill and a private bill, select the statements that are valid. Which statements are valid? Let's select those things. A private bill which has been introduced by a member of parliament sitting in the opposition is stressing that a private bill which has been introduced by MP sitting in the opposition and which has been approved by the House will have to be referred to the Law Department for consultation. So we'll ignore whether it should be referred to the Law Department for consultation or not. It's a second thought. Let's understand this after this. But before that, only it is saying that only the opposition person, an MP from the opposition party who introduces bill in the parliament, then only it will be called as private bill. Ani he is saying it is wrong. As I said before, any person, any MP, whether he is from the ruling party or from the opposition party, who is out of the cabinet, who is out of the council of ministers, is known as private bill. So this should be keep in mind. So by looking at this half of the statement itself, we can say it as wrong. Okay, so first eliminate 2 and 3 because here 1 is there. Next, what are the remaining options we have? 2 and 3 and only 4. So let's get into this, whether 2 is right or wrong. A public bill is always introduced in the parliament by the minister or a member of government party. See, here the thing is a public bill is always introduced in the parliament by minister. It is correct. But a member of the government party, as I said before, a member, an MP, whether he is from the party which was in rule, an MP who belongs to the opposition party, doesn't matter. If an MP who is not a part of council of ministers is known as private bill. So we can also eliminate this second statement also. So now we no need to study third and fourth one. The answer is 4. Understand? So this is how we should get into the answer. Next, let's look into this analysis of this question. The first one is incorrect because the procedure, which is an invented procedure, the approval of a private member's bill does not create the stated mandatory refer to the law department. No need to refer to the law department, which is not mentioned anywhere. So obviously, which is incorrect. The statement 1 is incorrect. The statement 2, which is a category trap, where a public bill is not defined by the ruling party membership. A non-minister MP remains a private member. Whether that MP belongs to particular ruling party or an opposition party doesn't matter. If he is a non-minister, if he is a non-minister, it will be declared as a private bill only. Next, third statement, it is also an incorrect one, policy trap. Next, the fourth one, as we discussed before, it is right. Next question. Reservation of state bills. Which of the following state bills will have to be mandatorily reserved for the president's consideration? So as we know, the governor has the power to give assent to the bill, can withhold the bill, can also reserve the bill for reconsideration of president. Yeah. So fourth one, he can return the bill. If it is non-money bill. A money bill cannot be returned. So these are the powers of the governor. Okay. Now let's get into the statements now. The basic understanding we have. We can solve this question with the basic understanding. A bill that proposes to give effect to certain DPSPs. A bill that proposes to give effect to the certain DPSPs. A bill requiring prior presidential sanction, but which has, however, not obtained under Article 304. A bill that attracts the provisions of Article 288. Here we have to understand what is Article 288 before judging this statement whether it is right or wrong. Next, fourth one, a bill seeking to operate a provision that belongs to one of the concurrent list entries, but which is, however, repugnant to any union law. See, here the first statement is wrong. Why? Because the first statement is involved in generalization of president powers, presidential reserve. Why? A bill that proposes to give effect, just merely certain bill that was proposed by the state government to give effect to certain DPSPs does not mean it will be reserved for the President of India, for the consent of President of India. So we can eliminate this first option so that we can eliminate option 1, option 2, option 4. The answer here is option 3. We no need to read any other statement here. If you could crack the first one, that we can arrive at the right answer. Next, CAG, the Comptroller and Auditor General of India. We all know. So the CAG, Comptroller and Auditor General of India, mentioned in Article 148 to 151 of the Constitution of India. So this is the basic information we should have in our mind before solving this question. Now, if you look into the statements, the CAG, consider the following statements in connection with the office of the CAG. CAG can be removed. The statement 1, the CAG can be removed by the President only in accordance with the procedure mentioned in the Constitution. But this does not mean that the CAG can be impeached from office in the same manner as Judge of the Supreme Court. In a single statement, he's giving two facts. First, he's saying that CAG can be removed by the President only in accordance with the procedure mentioned in the Constitution. But this does not mean that the CAG can be impeached from office in the same manner as Judge of the Supreme Court. The first half of that particular statement is right. But the second part of the question, which it says that the CAG does not mean CAG can be impeached from office in the same manner as Judge of the, it's wrong. CAG should be also removed in the same manner that was the impeachment process that is followed for the removal of the Supreme Court Judge of India. So statement 1 is wrong. So eliminate that statement 1. Option 1 and option 4 is eliminated because here the 1 is there and here also. Sorry, here 1 is not there. Okay, so option 1 is eliminated. The second one, some public corporations are audited exclusively by private professional auditors. Yes, some public corporations are audited exclusively by private professional auditors and the CAG may have no involvement at all. Okay, fine. We'll check this later. So here we have to, here we have to. Next, third statement, the CAG can conduct legal, regulatory and proprietary audit but not performance audit. This is wrong. CAG can do legal audit, CAG can do regulatory audit, CAG can do proprietary audit, and also the CAG can do performance audit also. So third statement is wrong. We have 3 here wrong. So we have 3 which is already eliminated. Now we have only 4 and only 2 and 4. The 4 is the determinant here. The Constitution of India has not specified any criteria for the appointment of the CAG. Yes, the Constitution of India has not mentioned any criteria in the Constitution of India. The CAG, about CAG, there is no any eligibilities or criteria that was mentioned. That's true. So 4 is true. And now we have to think about second statement. Some public corporations are audited exclusively by private professional auditors and the CAG may have no involvement at all. It's true. Yes. It is some public corporations, right? Few public corporations audited exclusively by private professional auditors. It is true. There is nothing, any extreme or any qualifier trap existed here to eliminate this option statement. So it's true. So the right answer is 4 here. Now let's check the answer here. Yes. What is the right answer? Answer 4, statement 2 and 4 are correct. The decisive eliminator is 3. CAG does not conduct performance audit. Yes. So this is the analysis of CAG question. So terminology trap, like we discussed, is saying that the Constitution provides removal in like manner and on like grounds of Supreme Court judge. The statements try to separate the procedures. So remember this, CAG, while removing the Controller and Auditor General of India from his position, the same impeachment procedure that was followed for the Supreme Court judge shall be followed. Okay, next question. It is a question on GST Council. So GST Council is also a constitutional body. Is a constitutional body under Article 279A of the Constitution of India. It was chaired by the Union Finance Minister. It consists of GST Council, consists of Finance Minister as a chair, state finance ministers. So this is the general composition of GST Council. Now, let's get into the answer now. Let's read the statements here. Yes, what is first statement? The GST Council was established as a statutory body, but it was later turned into a constitutional federal body by an amendment of the Constitution. Okay, what next? The proceedings of the GST Council will be invalidated in the eventuality of any defect in the appointment of a person as a member of the council. See, this is absolutely wrong. Just because of there is a defect in appointment of a person, it is not required to invalidate its proceedings. So absolutely wrong. Because any proceeding is a decision taken by the council. It's a group of members, not by a single person. If there is a defect identified or recognized in appointment of that particular person, doesn't mean that entire proceedings of the GST Council. So where 2 is there here? 2 there, 2 there. So now we have, so 4 is right. Without reading the fourth statements, we can declare it as right statement. Now we have to check first statement. The GST Council was established as a statutory body, but it was later turned into a constitutional federal body by an amendment of the Constitution. Yes, GST Council is not first statutory body, and then it is saying that first it was established as a statutory body, then the constitutional status was given to this GST Council. No, it's wrong. The GST Council established itself as a constitutional body under Article 279. So the first statement is also wrong. So we can eliminate the second option also. Finally, we have third option, which is only 4 is the right answer. Let's check the answer now. Yes, it's correct. Option 4 is correct. Article 279A includes recommendations on the turnover threshold below which goods and services may be exempted. Next question. So these are the 5 questions we have discussed today, which is previous year questions from 2023 notification, which was the prelims was conducted in 2024. So these 5 questions has given us good understanding of what APPSC is trying to do by complicating the questions, what traps it is setting there. Few of the traps, for example, that APPSC has tried. One is traps used by the examiner here. Partial truth trap. They are giving big statement. Only half of the statement is right, and the second half of the statement is deliberately putting a wrong statement. So any statement that has 2 facts, we should be careful in that particular statement. So that is the first learnings we should acquire from the previous year question paper. Absolute qualifier trap. We all know this, where there is a word like only, always, not, exclusively. Obviously, we should be careful in that kind of questions. Next, designation or authority trap. In the first question, if you look carefully, the whip, like the answer is Ministry of Parliamentary Affairs, but it was given as Minister of State for Parliamentary Affairs. So it is wrong. Next, category or terminology trap, which is a public versus private bill. Similar concepts are deliberately interchanged. They'll ask what is the difference between public bill and private bill, and they deliberately put some wrong point in that particular differentiation. So we have to be careful in reading that kind of things. Next, wrong institution of traps. For example, in the area, they'll give wrong ministry there. So we should be careful in that kind of questions. In the GST Council, see, it's a reverse rule trap. For example, what they said is Article 279. GST Council was first established as a statutory body, then it was given as constitutional status. It's wrong. Directly the constitutional status was given to GST Council under Article 279A. So that must be careful in this. So these are the few traps that was examiner of APPSC is using for the last few years. So we should be careful in upcoming examination also. So thank you for watching this video.